that in every August of every year, what we normally do is we have a moot court competition. It is named after our patron. It is the Lady Justice Joyce Alwoj International InterVarsity Moot Competition. And it's a competition where students come and they present their mediation skills. They compete to show that they can resolve trade disputes through mediation. It's every mid-August. This year it's between 17th of August to 21st, and you're all welcome to join us. And this webinar is part of the Pre-Moot webinars. We've been having a series. We've already had one last week, like about 3 weeks ago, actually. We had one webinar already, and now today we have our second webinar. So our webinar today is on mediation skills for consensus building in trade disputes. We are fortunate to have Assunta Dami, who is going to be our moderator. She's the founder and team lead at the Dispute Resolution Hub, Nairobi and Brussels. And she will be taking us through the entire webinar, telling us who our speakers are, what the topic today is really about. My work was just to warmly welcome you to this webinar. And something else I want to say, as long as you're online, please go to the chat and say, my name is this is the organization I'm from. For us, that is very useful information, even when we play back. We never know where we will need to collaborate with each and every one of you. So please drop a, hello, my name is XX, and this is the organization I'm coming from. So a very warm welcome and karibu sana. Over to you, Assunta.
Thank you very much, Florence. Very good way to start us off. So thank you very much, Florence. And I will begin by actually practicing the thing that she has just said. So I'm looking at the chat and I'm waiting to see individuals introducing themselves. Please tell us where you're joining us from, where you are coming or sitting today. I know some of you might be in transit. So even as we stream in, I will look at the chat for a second or so to see the engagement there. And this is also to welcome you to put in your questions in the chat. So this is a webinar, yes, an opportunity to learn second, but also one to interact. So your questions, your inquiries, your requests for clarification can all be done on the chat, and we welcome you to do exactly that. So right there, thank you very much, Anita. You are number one. Having said that you are from Strathmore University, thank you very much. Let us see, Justin, very nice to meet you as you join from Cavendish University in Zambia. I also see Philip saying he is joining from Lusaka, Zambia, and he's also a student at Cavendish. And then we have Priscilla, who is joining us. She works with African women in arbitration in Uganda, and she has loved the women in ADR work so far. So thank you very much, Priscilla. We have Joanne, who is working as an attaché from Kenyatta University, but currently an attaché at the Dispute Resolution Hub. Esther, I see you as well from Strathmore, so thank you very much. Please keep them coming. I will come back to the chat. So this is to inspire you to keep engaged throughout this webinar. So if you didn't catch something very clearly, if you think there's a specific speaker you need to address you, leave it in the chat and I promise we will come back to it. As Florence said, my name is Assunta Ndami, currently sitting in Brussels, but my work is cross-border, some bit in Africa and some bit in Europe. As the team lead of the Dispute Resolution Hub, it is my pleasure to welcome you and to moderate this session. The topic for today is mediation skills. And so the speakers for today are coming to chime in their experiences of mediation when it comes to trade disputes. So allow me to set the scene. When we think of trade disputes, as we speak this afternoon, think of it in two folds. We will be thinking through cross-border kind of disputes and how those happen and how is mediation applied in those disputes. Often we hear a lot of arbitration. So today we take a turn and listen more in on mediation. And in some situations, you'll hear from our speakers who are ADR practitioners and they've had the experiences between arbitration and mediation, and you'll hear about how those feed into each other. The second way you can look at the kind of trade disputes that we will be discussing today is with regards to a trade-driven economy and sectors that are affected by trade. So think about disputes such as manufacturing, the disputes that also occur in agribusinesses and agro-processing, the disputes that recur in maritime affairs, because when you have cross-border natures, then you're definitely going to also include maritime. So I have set the scene for you. Think in that context. Therefore, I welcome you to ask any questions to our speakers, and I would not do them enough justice if I introduced them myself. So I will allow each of them to introduce themselves as they come in, and then we will kick off. So allow me to hand over first to Phyllis Wangwe. And Phyllis comes in from Wangwe and Associates. Phyllis, the floor is yours. Please introduce yourself, and then you can hand over to Lois.
Oh, thank you very much, Assumpta. So I'm Phyllis Elaine Namachanja Wangwe, a practicing advocate of the High Court of Kenya. Under Women in ADR, I'm in charge of membership and training. But in my personal space, yes, I'm an advocate of the High Court of Kenya. I also happen to be a mediator, an arbitrator, and a conciliator. I am a trainer of trainers in mediation, both local and international. That would be domestic and international. And I also happen to run an NGO, SEED, Center for Economic Empowerment and Development, and PENS Global, ADR. So I'm very happy to be here today. This is really one of my fortes that I'm glad to be part of, because I also happen to be at the Chamber of Commerce. Thank you very much, Assumpta. Yes.
Thank you so much, Phyllis, and karibu sana. Ladies and gentlemen, if you can still hear us, a round of applause for Phyllis as she settles into her chair. Thank you very much. Philip is very fast with this button. Thank you, Philip.
You know, he's almost a namesake.
I can see. So Philip, if there was a sticker for today, we would give it to you. You've been very fast on the button. Thank you very much.
Thank you.
Great. And as Phyllis settles into her chair, ladies and gentlemen, allow me to hand over to Lois. Lois Warenge will be coming in as well with quite a robust experience in the practice of law and ADR. Lois, the floor is yours.
Good afternoon, everyone. I have seen the chat that we are cross-border really. So I'm happy to see everyone from everywhere where you're joining from. My name is Lois Oringe. I am founder at Law Mediators, and under Law Mediators, I built the brand L.A. Waringe Advocates. So we are joint. It first started as a mediation practice, and it grew to be an in-house ADR unit. We do litigation as well as all other aspects of mediation. So thank you so much for your time. I hope we learn from each other.
Thank you so much, Lois, and equally a round of applause for Lois as she settles in her seat. Great, thank you very much. Now to the next panelist, equally coming from a different country, allow me to cede the floor to Mr. Isaac. Isaac Ibinkule shall tell us exactly where he's seated. Isaac, the floor is yours.
Thank you, Assunta. My name is Isaac Ibikunle. I'm a dual qualified lawyer. I'm based in Nigeria, qualified both in Nigeria and New York. I'm also a scholar. I support scholarship work across the continent. At the moment, I lead the arbitration team at Olaniwa Ajayi, based in Lagos. And what we do essentially is to assist our clients in navigating their disputes in international arbitration, domestic arbitration, cross-border litigation, and international law. So that's where I sit at the moment. And I also work as a volunteer in some leadership role, such as a Young ICSID regional delegate for Sub-Saharan Africa. I also serve as a mentoring advisor at Young ICA and a host of other bodies that I represent. So essentially, dispute resolution, arbitration, mediation, and other ADR. It's a pleasure to be here, and it's a pleasure to be the only man in the mix.
Thank you very much, Isaac, and we appreciate the time you're taking, and we look forward to gaining from yourself and your fellow panelists with the vast experiences. Now, allow me to shift gears in a second. Isaac is already receiving his claps. Thank you very much, ladies and gentlemen, for going with the program. I will go back to the chat because I promised I will, and from there we can note that Esther Washuka is also joining us from Strathmore. There is Lola from Uganda, Makerere University. We have Daisy, who is a private mediator and a lawyer. Elfas from Moi University. Frederick from Uma University. Rahab, who is from Kabarak. Namata, who is from Cavendish in Zambia. And then we have Levis from Cavendish again, and Samantha and Derry from Strathmore. Thank you very much for introducing yourselves. Now, to start us off, remember I set the scene on the types of disputes that we are imagining. So our panelists will share specifically on how to apply mediation skills. I welcome you to take some very crucial notes, but also to ask for clarifications and scenarios that may come to your mind. To start us off, I will begin with Lois. Lois has a background of not only practicing the law from a law firm, as she said she started off, and then veered into ADR. Lois, you have had the background of seeing the court-annexed processes in our country and how our country has veered into being not just pro-arbitration, but pro-mediation. Now, from the back of that, what do you think we would then be offering from an institutional perspective when it comes to the application of mediation skills in trade disputes? Are we ready to share our practices to the world and to Africa, as you may say?
Yes, Assunta, thank you for that. That question is wide because it sets me to explain our whole system, the way disputes are referred to a single mediator or a court-annexed mediator. So what happens? Already there's a system built by the judiciary, because this is in regards to the court-annexed mediation, where there's a data on court-annexed mediators. Once a mediator is filling their data, they usually say which areas they are interested in practicing. So if the dispute involves that particular area, then the first thing, the secretariat will send you an email because you have left your details there. And upon receiving the email, what do? You respond. That is what we do. We call a notice of appointment. You respond and say that I'm interested, I will take up the matter. Following that, then now you get in touch with the parties or their advocate. Don't bypass the advocates, especially in this era. If there's an advocate, reach them. Let them know that the matter has been referred to mediation and you are the one who has been given conduct of that matter. Once you notify the parties, schedule a come, then you can begin. That is just a layout of the process that is in Kenya. So now once the parties come, you will try to resolve the issue. If it is resolvable, we can end up doing a settlement. This settlement, we take it to court and it is adopted as an order. If it is not settled, not all matters are settled. If it is not settled, then what happens? You can refer the matter back to court. Sometimes you might be able to solve issues partially. So there's also a space for that. You note down the issues that have been resolved, the issues that have not been resolved, then you file it in court. So the court will be able to determine the next way forward. That is just the layout of our court annex mediation structure in Kenya. Yes. So Assunta, I believe I have answered the first part of that question in regards to our sixth jurisdiction.
Yes, I believe you have. And now setting the stage for the fact that this has been done over a span of 10 years within our jurisdiction, specific to Kenya. Would you say that the system we have set up sets a very good example and template for other African jurisdictions when they're considering perhaps applying it to their countries?
What we have set up, I would say it sets a good precedent. But what I have observed before 2016 and from 2016 up to 2019, when the judiciary actively started creating awareness around it, there are not many people who are in touch with mediation, not many people knew about mediation. But once there was awareness that was around it, then the uptake became better. So now, in terms of the precedents, there has to be a structure, first of all, like we have laid down. But from the structure, what else comes into place? One, we have goodwill from the parties. Okay? The parties must have the goodwill to engage in mediation and to be bound by the terms of that mediation. The second thing that they can take as a precedent, is well-trained and professional mediators. So those who aspire to be mediators, make sure that it does not stop at 40 hours of training. Make sure that you are well-trained, you are up to date with everything that is happening on the ground in regards to the current legislations, in regards to everything that is happening. So you have to be well-trained and professional, know your role, know why you are there in the room. Don't impose on the parties. Let the parties decide because it's a self-determining process. The other thing, and this is in regards to the court annex mediation, we need the judicial support. So if the judiciary puts in place, like now we have the rules, 22 mediation rules. If we do not have somebody to push, like the way the judiciary has pushed, honestly, the judiciary has come through for the mediation. It has always supported. So we hope that the other countries speak as well. Somebody needs to push it out there. The other thing is that we need support from all stakeholders. This is not lawyers versus mediators. No. We need support from all stakeholders to be able to support the mediation process. So I think that is all I will say for now in regards to that, Assunta.
Yes, thank you very much, Lois. We'll be coming back to you to pull on the specific skills that now we'll be talking about. We hear you when we say we need to do more, but we also need a lot of goodwill from the many stakeholders, including those in this room today. I will shift just a bit because I know as Lois has set up the stage, the experience within the court annexed system sees a lot more commercial matters, right? And commercial, we think, is B2C, B2B kind of disputes that are solved at that level. Phyllis, on your end, as you sit at the Chamber of Commerce, and now you're dealing with beyond B2B, and we introduce the whole elements of cross-border trade, right? From your experiences, how do cross-border disputes differ so much from what we're seeing in the court when it's commercial matters?
Thank you, Assunta and Lois, for elaborating what happens at the court annex mediation. locally. You've given a good background. And now just on top of that, probably what I can say is that cross-border disputes are rarely just about the contract. They carry layers of complexity because remember, these are different jurisdictions with different currencies, different regulatory systems, and even enforcement challenges. The cultures sometimes are also different because once you're dealing with trade, then you must deal with the community. And when you're dealing with the community, you realize the communities usually have different ways of approaching issues. One example, for example, is I once advised a Kenyan exporter whose payments were delayed in Nigeria due to foreign exchange restrictions. The dispute wasn't simply about non-payments. On top of that, there was navigating two legal systems. There are banking regulations, which may be different as you move from one country to the other, and also reputational risk of all the parties that are involved. If, for example, they may end up losing a trading partner, that is something that also had to be looked into even as we were navigating the challenge. So unlike ordinary commercial disputes, these cases demand solutions that preserve the relationship while cutting through systemic barriers. In the sense that it's not just the contract that you're looking at. You're looking at a cross-section of things. And you can't just get up and decide that one approach fits it all. But the beauty now of approaching it through mediation is that mediation, because of the way it is structured, provides neutral ground to all the parties. Then it ends up being cheaper, it ends up being faster, and also the relationships are preserved. One thing that we have to understand is that our cultures are different. Just the other day, a colleague was calling me from Cameroon, and he was telling me, there's a problem with you Kenyans. And I asked why. He said the problem with Kenyans is when they don't want to move on with a particular transaction, they just go quiet on you. And for those who are Kenyans here, I'd like to hear your feedback on that. That you see, if a deal is not going to go through, they don't just tell you head on that this is not going to go through. They just keep quiet on you, and suddenly you find your emails are not being answered, and it all goes quiet. So you realize our cultures are different. He says him being a Cameroonian and having been in the war and all that, when he has an issue, and the dad, for example, if the dad asks him to do something and he knows he can't do it, he respectively tells the father he will not. But he finds that is not very common amongst Kenyans. Kenyans, we just go quiet on you when we don't agree with what you're saying. We don't come out and forcefully, categorically say no. So you find those are some of the challenges that we'll deal with in cross-border disputes. You find that cultures are different, and the way the parties deal with disputes, the way they deal with transactions, the way they deal with negotiations tend to vary. But the beauty of mediation is that we are able to put everything down on a neutral ground for all the parties to understand each other, and then we can move on from there as relationships are preserved. Thank you.
Thank you so much, Phyllis. And I will take the question and let it hang. We will actually be asking our attendees, what do you guys do, right? We have Zambia represented, we have Uganda represented, Nigeria. So ladies and gentlemen, we will be coming to ask you, how do you deal with your disputes? Are you Kenyan like us? And Kenyans also vary in shapes and sizes. So sometimes we say yes and then we don't do it. So that's also a Kenyan tick for those in the room who've not dealt with Kenyans. Isaac, Phyllis has said mediation is the best we can offer when we consider all these things that we need to consider, whether it's culture, whether it's reputational risk. But as my fellow practitioner, we know for a fact arbitration has been the pick-me, right? It often is not mediation. I'd be curious to hear from your experiences, both locally, that is within the African context, and now in the respective tribunals you've had. Do you have situations where you actually tell the client mediation is preferred to arbitration? And if it is, then why?
Thank you, Asunta, for your question, and thanks to my co-panelists for laying the foundation for this conversation. So I think I will start with what my experience has been like across the shores of Africa, borders of Africa. Yes, arbitration has been there, litigation has been there, but mediation is also making its inroad. And based on my experience, now more than before, we now have what we call the multi-layered clauses, right? And unlike before, when you just advise the client and say, oh, if dispute arises, then just have a boilerplate provision, then go to so court or do arbitration. Now we try to stagger it. Oh, start with negotiation, then go to mediation. If negotiation does not succeed, then go to mediation and then arbitration or litigation. And why do we do that? Some of the reasons have been advanced. Relationship, we want to keep the relationship. But there's also another aspect, reasons for it, or maybe based on our own experience. Now, when you have some project or some transactions across borders, for instance, supply of goods, right? And those supplies are going to be in phases. Or you have construction, right? And they are going to be in phases. You want to do solar power and somebody's financing from Nigeria, the person carrying it out is in Kenya or is in Kigali. Now, it's going to be in phases. So we are going to do this contract in 3 phases. First, do 25 plants, additional 20 plants, then we go there like 4 times, right? You don't want, and dispute is inevitable. You don't want to just have a clause where whenever there is dispute, you just have to go through litigation or go to arbitration and start spending everything. So what you do in that scenario is, oh, okay, put in a negotiation first, or you can even start with mediation, but usually advisable put negotiation. And depending on your framing, it's also what we do. It's not just to say go negotiation, mediation. There are some framing around this. Negotiation, you can say within 3 weeks, depending on how you see the modus operandi, the system operates between the parties. Then after that, then you can also include mediation and also prescribe time. Now, one thing you also see, in addition to time, when it comes to mediation these days, is to also specify the rules that will guide the mediation. Because you don't want a situation where you have a mediation clause, a multi-layer clause that has a mediation provision, and that mediation provision is not honored, right? When there's dispute, people may just want to do what they like. So you put the relevant rules, you can say the SCIA rules, ICC rules, then we have different jurisdictions in Nigeria. We have our AMA. We have certain rules there that also governs mediation, right? You put the rules so that the timeline within the rules will guide the parties. They know when to stop, when to start, initiate the mediation, who to appoint, where to apply to get the appointment, and things like that. So then before you go to arbitration. So for me, it's the experience more about multi-layered clause where you now have mediation included. And in a number of times, we've seen parties stop at the negotiation, we've seen parties stop at mediation without even going to arbitration. So that is the significance, the relevance, and the stakes of mediation in that kind of process. Then I've also mentioned when you have contracts that has to do with supply, and those supply or construction are going to be in phases, it's always advisable to have mediation and negotiation as the first year of dispute resolution. Another instance you can even say, you should also have mediation is when the value is small, right? I've been involved in one transaction that has to do with a cross-border transaction, right? 2 countries within Africa. And we're looking at the value. If you have to go to arbitration, hey, this doesn't make sense. Why not put mediation? Then if parties are not unable to settle, then maybe they go to court. So these are some of the instances where you include mediation based in the system, based on what I've seen. Yeah.
Thank you very much, Isaac. I feel like you had just started off, and we're going to come back to you to ask the practicality of applying these clauses in time, right? As you say, multi-tiered is the way to go. Have negotiation, mediation, and escalating all the way to arbitration. I'll be coming back to ask, when can we apply mediation and arbitration together, right? But just before I come to that, Lois, I'm back with you and the practice of the law itself. We know very much we are, in Africa, for example, we have almost, 1.4 billion of us, and we practice very differently, even this law that we talk about. When it comes to circumstances, from your experience where you have common law trained versus civil law trained, have you seen situations where that can be a challenge even in the mediation process itself or in ADR?
Yes, Asunta, and thank you for that question. Like you said, we are from all cultures, and this is in regards to law. Some are civil law, some are common law, others are even the cultural practices. All those may be conflicting against each other. Like now, in the case of Kenya, we are common law. Usually, if it is not in the contract, it does not apply. You see, the people in the civil law, they're more of implied, okay? Even if it was not in the contract, there was that good faith. We can continue with the performance. So I have handled an issue mostly regarding the trade, especially with the Chinese. And for Chinese, where there's a breach of contract or where there's a breach, what I have noticed, they are willing to perform. They are willing to set it aside and see what can we do to address that. But in our Kenyan context, what I've seen is we are more of in the contract. If it is not, if you have breached, then pay me for it. If you don't pay me, we will leave in court. Those are some of the conflicts that I've been able to address. So in addressing such conflicts, I have also learned to differentiate the two systems. But in the course of mediation, you will not, the systems will not be the highlight of the day. No, we must move parties away from that common law and civil law system. Okay, we must endeavor to bridge those two systems and bring the parties to the table and find a way forward beyond these two systems. How can we move forward? So the ground, if there was good faith from the beginning, this person will see that maybe the process, there was no malice. It's only maybe an act of God happened that you are not able to supply within the required time. Or God forbid, they packed some standard goods and left the ones that I had ordered. So if you're able to show that, and the parties are able to see that there was no malice behind the breach, then now that is the way you can be able to move forward. Those are some of the challenges I have seen in regards to the systems. But away from the systems, we must find the common ground on what was breached and how it can be addressed. Most of the time, it's just that. Once we move beyond the systems, then we can be able to address any issue. So that is it.
Thank you very much, Lois. So you're reminding us to look beyond the systems. Let's not be too focused on how we were trained and more focused around our commonalities and how we need to move these things forward. Thank you so much, Lois. And it's interesting you say good faith, because it's very hard to find good faith where there's money. Those two things seem to clash consistently. And Phyllis, seated at the Chamber of Commerce, would possibly be telling us, often when there is money, the good faith might be a bit challenging. Phyllis, in some situations, there's the power imbalance that we see. For example, I will use just what Lois has given us, a situation where you have possibly an Asian provider or an Asian supplier or contractor. And then we are coming in to be either the ones being served and under very strict deadlines for this thing to become a reality, whatever it is. It may bring some imbalance in some situations when we're talking about what is at stake. From your experience, how do we deal with that? Where you clearly see an imbalance and parties may be unable to see past the good faith that Lois has said, and they are too centered on the cost of the dispute in itself. What do we apply then?
Okay. Well, first, let me clarify. At the Chamber of Commerce, I'm a trustee. I don't sit there 24/7.
Noted.
Yes. But what would happen in such a case? Many times what we do is using caucuses. And that is having the parties in different rooms at some point and helping them understand each other's perspectives. Because it's in understanding each other's perspectives that which is really the basis of mediation, that we can be able to navigate the process. And for example, if depending on the two parties, whoever of them is more powerful than the other, it's really a matter of sitting with them in different rooms, because again, you can't, there are some things you can't negotiate when they're both looking at each other, because it will look like you're biased. But for example, for let's say the company that is more powerful than the other, probably in the caucus session, what we'd be concentrating on is asking them, okay, fine, you can get your way down, you can get your way out transactionally from the legal perspective. But what then is your reputation as a company? Are you taking advantage of smaller companies, or are you trading fairly? So that we say it's not just a matter of just winning the case this one particular time, but looking more at future transactions. So that the person who is stronger, we probably would be telling them, don't just look at this one, but going forward, maybe we just be more careful how we draft the contracts and how we negotiate and what the timelines are. But if you're going to just insist on maybe the timelines, and yet that person is more powerful and probably has access to a lot of machinery that things can be done very fast, and yet the other team on the other side are a bit more manual, and they can only do their best within their confines of the machinery and the labor that they have, then we negotiate somehow, facilitate, so that they can come up with some kind of balance. And maybe I'd also just use another small example on that, whereby there is a small company in Kenya, relatively small. Okay, it's big, but relatively small in Kenya. And the multinational was pulling out. So the multinational insists that they have to put, okay, the contract was abruptly stopped. So they insist that as they're leaving, they have to leave with the machinery. But the small company says, according to the contract that we had at the end of 5 years, since we're the ones implementing this project, the machinery remains with us. So with us, or my perspective, what I did was to get the multinational to look at it from all aspects, and just get them to understand that it's not just the machinery, but there's a lot more that can be looked into. And also the fact that, for example, the project was being terminated halfway. There is the element of how much would have been paid for the whole of the 5 years, yet now it was only 2 years. So it's like, why don't you just consider agreeing to what they're asking, and then in the process, maybe trade off what you'd have paid off, what you'd have paid, or what the project would have cost for the whole 5 years. And you see, this is a project of billions. So you navigate it that way, and you look at what would the parties both be comfortable with without losing out too much also on each other. So for the small company, machinery is what was very critical to them. And for the big company, their reputation is at risk because remember, these are big organizations, and they don't want us. We are not to go to court and we start tagging at each other and damaging each other's reputations here and there. So based on that, they did agree to the mediation, and just using the skills that we have, it's not so much of a David versus Goliath scenario, but more of how do we bring the partners to work together in continuity, so that even if they've not finished the contract because some partners have pulled off at 2.5 years, then should anything also come up, they can still come back to this organization that they had worked with before and work on from there.
Thank you.
I hope I've answered you.
Yes, absolutely. So I'm picking up on the fact that we can use caucuses, and then we can use reality testing as well. And looking at the value of their reputational risk, we can also do our BATNAs, our WATNAs, LATNAs, which for the mediators in the room, your best alternatives, your worst alternatives, are also skills that you can apply in such disputes. As you have shared with us, Phyllis, I am reminded that Isaac left us with a bit to think about when it comes to our multi-tiered clauses. And Isaac was mentioning timelines of set a time for negotiation, set a time for mediation, and then escalate to arbitration, right? Now, Phyllis, you cut across and tell us if that doesn't work, then caucus it, reality test it, and maybe you will find that parties are drawn more towards the commonalities that Lois is saying and the good faith to remember we are all here to accomplish a goal. Isaac, if I may ask from your experiences, either as the arbitrator applying mediation or the mediator being the arbitrator, when have you had a situation to handle MedArb as a technique?
Okay. So now, just like I mentioned earlier on, when you have a multi-tier clause in your arbitration, right? I mean, in your contract, you have to go through, if it is carefully framed, you have to go through each of the stages. Right? So if you have mediation as a first step, right, you have to go through mediation before arbitration. Now, I, without divulging too much, currently dealing with a matter, right, which has to do with mediation and arbitration. And mediation and arbitration under some major arbitral institutional rules, right? And because the way the language was carefully drafted, we have to explore, mediation first, right? And the beauty of that is in mediation, the process will be confidential, right? Just like arbitration as well. But the advantage is that whatever you discuss during the mediation, right, cannot be used during arbitration. You know, one thing is that negotiation, right, where even when you have without prejudice clause protecting your negotiation, the law has moved to create some instances when you can actually divulge and use those things that you discuss during negotiation in litigation, right? Or even in arbitration, if you are subjected to relevant national laws. Or in mediation, because we are subject to the institutional rules, in this particular one, we are very much comfortable, right, to discuss and discuss freely because the rules are clear. Whatever we discuss here cannot be used in the subsequent arbitration if we don't succeed, right? So that advantage is there for mediation, and that's something I've been looking at. Okay, this makes sense. Unlike pure negotiation that may not have that coverage, that without full absolute without prejudice coverage. So then, if mediation, we've seen instances, I've been instances where mediation failed, right? Parties were unable to agree. Then we go to arbitration and we present our case. But one thing is this: when you are going to arbitration, you have to appoint a new person to sit as arbitrator. Even when you are dealing with the same institution, it's always almost very advisable that you appoint a new person that is not colored by whatever has happened, transpired during mediation, right? So that new person will not be the one to take over the arbitration. Now, this is when mediation comes before arbitration. What happens if there is no mediation clause, but parties are in arbitration, right? And they're like, okay, can we settle this matter? It's possible that the other party has gone to arbitration because they can't reach a settlement, and there are some interest assets that are wasted, and you need some injunction to stop it, and you want to get those injunctions in arbitration are not caught, right? You go to arbitration, you appoint your emergency arbitrator, and you process that. But both parties come and say, okay, can we slow down? Can we talk again, right? And they're like, the other party maybe, I'm not ready to talk to you again. I can't trust you, right? Then what will happen is we can say, okay, can we appoint a mediator? In this instance, it's not advisable to ask the arbitrator to mediate. No. What you will do is get a third party to mediate. The institution that is overseeing the arbitration may also have provisions for mediation. So you just key it into that, enter into a mediation agreement, and say we want to mediate. So those are the two scenarios and things that are obtainable in the process of having mediation, either before or within arbitration. I don't know if that covers some of your questions.
Just a second. We have an additional panelist though. Allow me to request the host to just.
I thought I knew about another one. How much is it?
All right, Mr. Ekaran.
Yes.
Welcome very much. I have noted you are unmuted, and we were
Yes.
just finishing a point from Isaac. Would you have a question?
My question already has been answered.
This was while Isaac was speaking.
My question was answered already by my colleague.
All right. Thank you very much, Mr. Ekaran.
Yeah. Thank you.
Okay.
Yes.
Isaac, I can see we are moving very well. I think people had questions and you answered them. And I was going to say, yes, thank you very much for that, Isaac. I believe the point you have brought across on how to integrate mediation within an arbitration process is very important for even those to take up who practice ad hoc arbitration to take up this as a best practice, right? So Isaac, I'll be back to you in terms of institutional frameworks and architectures, and more so how much support we can receive or things that we can consider from an African perspective when it comes to the Singapore Convention. But before I get you, Isaac, on this one, you brought a very good point on trust and the break of trust, that once it has gone, mediation is very good to rebuild trust among the parties, right? And you were saying people have already run either to court or to the arbitrator. Everyone is seeking interim measures, and arbitration allows them to hold on and cool down, right? Would this be one of the hardest things that you have experienced when it comes to trade disputes, that the lack of trust is what completely shatters the experience? And I'll be also stretching this over to Lois and to Phyllis. What is the hardest trust building barrier that you have seen, and how did you overcome it? Isaac, maybe you want to chime in a bit?
Oh, okay. So, yes. So it's one very challenging thing with dispute, or when parties are talking in negotiation or mediation, is when you perceive that. Do we have a question? I think we can see. It appears that Mr. Ekara is still speaking.
So I think the host can help to mute.
Hakuna do unaekanga hata mimi nauchingi mpaka ufike 1 million likes.
Mr. Ekaran. I think we are good to go now. So our hosts, please, you can assist to mute Mr. Ekaran. Isaac, you may proceed.
Okay, so in dispute resolution, especially in the mediation, when or in negotiation, when parties are talking, one thing that usually shake consensus building is when the other party feels that I can't trust this other party. This other party is negotiating or discussing with me in bad faith, right? And I'll give you an example. Parties were talking, a contract was supposed to be completed. The financier is a foreign party, has advanced the fund. Now, the contractor is supposed to complete the project within a timeline. The contractor failed to complete the project, and issues arose, and the financier started asking questions. Now, they set up meetings. They brought in third parties who could mediate between them. Conversations were going on, and we were representing the financier, and we were like, okay, let's talk. But before we knew it, the contractor has gone to court to get an order tying the hand of the financier. And we were like, what? So while we were talking in good faith, we were thinking we should solve this. The third party who is mediating was saying we should solve it, and we were considering different solutions. So you went to court and to get another interim relief pending arbitration against us. I've seen so many instances. But one thing we are very good at is, yes, bring your order. It's our duty as counsel to level the playing ground. Now, when you parties are talking, or either through negotiation or mediation or other ADR means, the playing ground must be leveled. And when the other party has gone, one of the parties has gone to court or arbitration to get emergency reliefs, then you've changed the dynamics, you've changed the floor. So that will raise a concern of bad faith from the other part, from the affected party, the one on the receiving end, and will not want to go ahead with negotiation or mediation in the same manner, right? But what we did was to, go to court, look at the orders, go to court and challenge the order, and this order cannot stand. And we raised a number of objections, and we succeeded in doing that, right? And after we succeeded, and I can tell you, parties are back talking, right? Because they can see that, okay, the order is no longer there. So both parties are exposed. They know that they need to reach an agreement. No one is saying, oh, I can just tie them down in court or tie them down in arbitration. No, you can't tie anybody down. Let's negotiate in good faith with level playing ground. It was by leveling the playing ground that we were able to bring both parties together, and they are about reaching settlements. So I think that's one experience I've had recently. Yeah.
A very valid experience. I'm calling it leveling the playing ground, right? Using the law that we know to level the playing ground. Thank you very much. Lois and Phyllis, over to you. Some experiences in terms of what are the hardest trust building barriers you've seen in such disputes, and how do we get over them?
Asunta, mine is similar to Isaac, because we were here doing our mediation and thinking everything is going well. We were thinking everyone is on the same page. In fact, we were looking forward to a settlement. only to realize the other party had gone to file a matter in court. So that threw the good faith out of the window. So that is one of the mediation which I let go of. And I think you can save some and some you cannot save. Yeah, as long as the parties are willing, good faith is good, self-determination is good, but if one of the parties fails on that, then you as a mediator, there's nothing you can do, you just let it go. So that is one of the trust barriers I have had to deal with. Yeah.
Learning to let it go, that's a skill in itself. Phyllis, over to you.
Yes, several times that has come up. You find that sometimes you're negotiating and then you have to take a break. When you take a break, you had made so much progress, but when people come, some of them shift goals. They are not accepting where you had stopped. And under normal circumstances in mediation, you're not really supposed to take notes because it's supposed to be something very confidential. So I've seen that happening, and now one party feels frustrated that we had negotiated till this point. So where is the good faith in this particular case? And another one that I've seen happen a few times is where one party, yes, it's in good faith, and one party starts ceding the ground so that they keep coming closer, but one party is just stuck on where they began. So you see the other party is like, okay, we're negotiating, I'm ceding ground, but what about the other party? And sometimes they can be so hostile. It happens, mediation is no guarantee. But then you find that happening. So you try your best as a facilitator to break that impasse. And you try caucuses and all that. But sometimes some parties are just hell-bent. They don't shift. From the time they came, you're trying to explain to them, look here, this party at least has ceded this ground. Why don't you also cede some? Then you find they'll cede until a certain point, then they revert back to where they had begun. So that can get tricky. And one of the things sometimes you do, sometimes a party can actually tell you that, look here, you're being unfair, you're listening to this other party more or something like that. Yet sometimes you find in the process of the discussion, you find one party maybe has much more to say than the other party. So you're listening to them until they finish talking. But one party insists you're listening to the other more. So in such cases, sometimes then what you just do is, okay, 5 minutes, 5 minutes, 5 minutes, 5 minutes. They'll seem to accept that more. And they don't mind being quiet. If it's their 5 minutes, let me be quiet in my 5 minutes. And if this person is talking, let him finish within 5 minutes. So sometimes there's that delicate balance. And mark you, these are different cultures. They view things differently. So that delicate balance of having them to really get to understand you and know that you're acting in the best interest of both of them. Thank you.
Thank you very much, Phyllis. Time-bound situations, right? Bound by the clock. I almost laughed because you reminded me of a scenario where the party literally asked me to bring in a clock and they'd keep checking the time. It was the most peculiar thing I had seen, dealing with a European party and an African party, and their dispute was about a few millions involved in their trade. They had been supplying each other back and forth for about 5 years. But suddenly the most important thing in that room became about the clock. So I thought time bound was quite funny because it's helped me reflect.
And wait, and the interesting thing about that is that, generally as Africans, we don't go so much by the clock. Yes. We go with the sun. So those are some of those cultural differences we have to factor in when you're dealing with some of these disputes. Thank you.
Thank you so much, Phyllis. I will allow all our panelists first to take a breather and back to our attendees. As moderator, it is my job to make sure we are still awake after lunch and very ready to engage. So ladies and gentlemen, please give a round of applause to our panelists for hacking it through an hour. They have a few more minutes left. And even as we receive and give these flowers, I will be coming back to the chat, right? I promised I would, and I am back here because at this point it would be good to, one, know who's in the room, but also second, to check if we have any questions. So for the next 5 to 7 minutes, as our panelists take a breath and take some water and smile at their flowers, we will be checking the chat. So where we left it off is we had Samantha from Strathmore. She is attending. She was the last person to note in attendance. I note Joshua from Egerton University is here, as well as Ogutu, who is an attaché at Thika Lokot. We have Patricia Muiti, a managing partner at CN Muiti & Co., as well as a certified professional mediator and a court annexed mediator. Welcome very much. Philip, thank you for your participation so far. We see a question and Lois will be picking up in our Q&A in the next minute or so. I note Brilliant Baraka, who is from Kabarak. Faith Irene gives you your flowers. Our dear panelists, please receive them with joy. Nzisa or Regina, I believe, is also in attendance. And then we have Immaculate Njambi from Strathmore here. Thank you very much for attending. We see you. Now we come to the questions. I will be looking at the questions we've received. And to start us off, we have a question for Lois, where we are asking or being asked by Philip whether he is right to conclude that the time limitations of 60 to 70 days in the Kenyan legal framework excludes the possibility of a stronger party weaponizing mediation with delay tactics. So does the time prescribed exclude the possibility of weaponizing mediation? Lois, over to you for this question.
Thank you, Philip, for that question. And to begin with, we must realize what mediation is. Let us go down back to the principles of mediation. One being that it is party-driven, okay? And it is self-determining. So it is for you to decide the time that the mediation is going to take place. Like now, the court annexed, we are given 60 days. But I have done mediations in a day. I have done them in 2 weeks. I have done them in the 60 days. So I don't think at any point it weaponizes or does anything. But what we must realize, Philip, is that when you come for mediation, in the first 2 sittings, I will know whether you want to resolve the dispute or not. And if the mediator knows that these persons are doing delay tactics using mediation, they can refer the matter back to court. Okay? Because normally, if they don't comply, because now you have to take the attendance sheet. If they don't come for the mediation as scheduled, they have not complied. So the law gives you a leeway to also write a report, a non-compliance report for the offending parties and refer the matter back. So if you feel that they are delaying using the mediation 60 days, the mediator can always see that, and the law gives them a way forward in dealing with such situations. Have I answered your question, Philip? Thank you.
Philip, I believe you're with us. You can unmute and confirm if your question has been answered. All right. Philip will not unmute, but I have seen his comment in the chat. Lois, he confirms he is well guided. Thank you very much. Now, there is an additional question as to whether we will be sharing the recording of this. I believe Florence, Eunice, and the rest of the women in ADR team will confirm this at the end of the webinar on whether the recording will be shared since it's being done. That is an additional question. Isaac, a question for you with regards to the ratification of the Singapore Convention on Mediation. Noting that we hadn't quite touched on it, but we were going towards it. Maybe you can take the minute to help us and in attendance understand the importance of the Singapore Convention on Mediation? And does it mean that with the ratification of it in different countries, we expect to see a different kind of practice and how it would affect how we do our trade disputes?
Yeah, thank you again, Asunta, for that question. So, Singapore Convention on Mediation has come to stay. And before I talk about Singapore Convention, Mediation Convention, I think it's good to start with what we are familiar with before we go to what is new. And what are we familiar with at the moment? We are familiar with the New York Convention on the recognition and enforcement of foreign awards. Right. The New York Convention deals with, it's an instrument where parties agree to recognize and enforce foreign arbitral award, right? Now, the Singapore Convention on Mediation, what it's doing is, while New York Convention is dealing with arbitral award, Singapore Mediation Convention is dealing with mediation agreement, mediated agreement, right? And mediated agreement when it is international, across borders. For instance, where the parties are from different jurisdictions, or they are within the same jurisdiction, but they have some connection with other jurisdictions. The coordinating guideline is that the parties or the subject matter are across borders. So now when you take the New York Convention, you can come under it, make application. When you get your award, you get your award in Nigeria. Maybe Nigeria is a seat. You go to Zimbabwe to go and enforce, and you come by way of an application under the New York Convention, and you enforce. The same thing with a similar thing that the Singapore Mediation Convention is also doing. If you have a mediated settlement in Nigeria, right, and Kigali, Rwanda is a party to, but I'm not sure if Rwanda is a party yet. Let's assume that Rwanda is a party to the Mediation Convention, the Singapore Mediation Convention. You can go to Kigali to go and enforce, right? I'm aware that Nigeria is a party to the convention. So if you get your settlement, your mediated settlement agreement anywhere in the world, you can come to Nigeria and come and enforce it, relying on the Singapore Mediation Convention, right? So that is essentially the overview about Singapore Mediation Convention. And it has come to stay. I think we've started seeing countries subscribing to it, becoming parties, and domesticating the convention where domestication is required. Like in Nigeria, the Singapore Mediation Convention has been domesticated by virtue of Part 2 of the Arbitration and Mediation Act 2023 in Nigeria. So it's in full force in Nigeria, and if you get your mediated settlement agreement, please feel free to come to Nigeria to enforce.
Thank you very much, Isaac, and for welcoming us to Nigeria to enforce. We hope that other African countries will join you in ratifying this very, very important convention. As I had promised our attendees that we'd like to learn from their cultures, right? We have heard about several skills over the past hour that we can apply towards trade disputes. And I hope you've taken notes of what our panelists have very well shared with us. It is now the time for the attendees to teach us a few things about their culture. For example, you had Lois and Phyllis tell us Kenyans will just go quiet on you. I chimed in to add that if we don't go quiet, we will say yes, and we may never do anything. That's a very important note. It cuts across all forms of interactions. So now, our dear attendees, from your cultures in the chat, how do you deal with disputes? Do parties also go quiet when they're not in agreement in your different cultures, or do they raise the issue? Please feel free to write it in the chat. What do you do in your cultures? It's an opportunity for us to learn. Kelvin Egesa, we see you. Thank you very much. Would you like to chime into how your cultures deal with disputes? Okay, I know I have just asked the question and you are chiming in. Whitney Akinyi from USIU Africa, thank you for joining us. Teta Benita from Makerere, thank you for joining us as well. Feel free for our brothers and sisters from Uganda, Zambia, Nigeria, Malawi, to teach us about your cultures. How do you deal with disputes? And we'll take those notes. The chat is always open, and as I have promised, I'll be looking out for it. So our panelists, you've told us and shared about the skills themselves, from caucuses to time-bound sessions, to learning when to let it go, to having multi-tiered clauses. And these are skills that we need to apply. Considering that our cultures are different and we practice differently, we also have opportunities where we should forget how we are trained legally. And instead of that, we should practice good faith and move beyond the dispute itself. Elfas, thank you for contributing. He says that he's very outspoken and rarely goes quiet before he backs out, and he makes you know why. Elfas, if you can also add maybe where you're from, and we'll take that note. It might be unique to you or also unique to your culture. You can tell us where you're from. Priscilla says Ugandans generally aren't known for being very confrontational. If there's a dispute, many people will first stay quiet, vent to their friends or family, or ask someone respected to intervene before addressing the person directly. It has made mediation difficult because parties are not forthcoming. So Lois and Isaac and Phyllis, I think that's an extra note for you as you practice with Ugandan parties. If you stonewall on a mediation, you might just know why it's happening. Thank you very much, Priscilla, for that. I also do note that if you're interested in becoming a member of the Women in ADR, in the chat, you will see a link to become a member of Women in ADR. Elfas, thank you for clarifying. Kenyan it is, so you're a very rare Kenyan who doesn't keep quiet. We need you in our next few years as a country. Thank you for that clarification. Now, many who have joined are practitioners or practitioners to be. And what I always find essential in every session is to have the experts reflect on why they started this path. And if they were to share this with the younger selves, now some of you in the room, what would they share about how to start off? We started with getting perspectives of what trade disputes we talk about. For some of us, they may seem very far-fetched because we are yet to build a niche in the industry. And maybe that's why you have joined this call today, to understand, where do I start? So I will allow our panelists to share where they started and what note you can take. And there I shall start with Phyllis, who not only balances litigation, she also balances the work she does within the community with the NGOs. And you balance also professionally as you sit as a trustee. But where did you start, given a chance to do it all over again? Where would you start? What kind of training or experience would help you cut across the many years you've had to work?
Interesting. Actually, I started out as a banker. And while I was working at the bank, I did my law degree. And it wasn't until the 4th year that I learned about ADR. And I was very surprised to learn that ADR existed and wondered why nobody had told me about it. So yes, if we go to court, yes, I can be litigious and all that. But I found this, it made so much sense, and I wondered why people had not taken it up. So I stayed on in the bank, finished my law degree, worked on in the bank for some time. And when I was ready to leave the banking practice to start my law firm, I actually thought I'd just do ADR and ADR alone. Now, ADR was not paying my bills. So I cut across to the other parts of law, insurance and all. But as my law firm has expanded, what has happened is that I now concentrate more of ADR, and the firm does the litigation issues. Because you realize that there's a place for everything. And much as we are advocating for mediation and ADR, alternative dispute resolution, or African dispute resolution, or appropriate dispute resolution, we call it in different ways, there's still the place also for litigation. It's not like we want litigation totally overhauled. No, there's a place for each. So it happens that in the law firm, I focus on ADR, and the ones who like litigation focus on litigation. Would I do it differently? I don't think I'd do it differently. It's just good that it has worked out the way it has, because by the time I was starting the law practice and wanting to do just ADR, it wasn't very, very much accepted, because that was in the early, after around 2014, thereabouts. And you find that the court has also done so much to create awareness on the ADR. And as such, now there's much more uptake. At some point, disputants felt like if they didn't go to court, they were being denied their justice. But now, as we've moved more into it and more awareness is being created, and even amongst the lawyers, as long as it's not biting on our fee note, as long as we are still paid our legal fees for instituting or dealing with the dispute, then more lawyers have come on board, and they actually don't mind if their clients can negotiate and come to a settlement. Because one of the things you realize in the mediation space, sometimes it's very tricky when the lawyer is not supporting the mediation process. So the buy-in from the lawyers is very important. Buy-in from all the stakeholders is very important. So, and personally, having been in the banking sector before getting into the legal section, so my strength tends to be commercial, and that's where I am at. I'm also a mediator with the Court of Appeal. But also, because of my background, organizational development, I'm also a trainer in the mediation space. Just briefly that. I know I could talk much more on the details, but just basically that is where I got into where I am at the moment. And I'm very passionate about it. I'm very passionate about empowering the community on dealing with disputes. And as much as possible, my approach usually when I'm training communities is more of proactive and not reactive. Equipping them with tools on how to deal with disputes before they escalate to the position where they'll have to go to court. Because I'm such a peace lover and would love the communities to have peace amongst themselves. Not negating the place for litigation, there's still the place for litigation for the very complex matters. But as much as possible, let's only what really needs to go to court, because already the court system is overloaded. Thank you.
Thank you, Phyllis. And understanding how to layer it all is what I hear, right? There's a place for everything. And in your life, you've gone figuring it out, placing the things in your life as well.
Yes.
Isaac, back to you. You have definitely a very different experience from Phyllis. And mine would be the same question. Reflecting back, would you still pursue your academics out of the country, out of the continent? Would you come back? How do you build this mediation practice?
Okay, thank you. That's a good one. So I think I would say, in terms of what you should do, if you have passion for mediation or ATR generally, first get qualified as a lawyer, either at least in one jurisdiction. It's very important. The basic knowledge of law will assist you so much when you are mediating, right? There's nothing any of the party will tell you in law that you will not understand. So with that, you have every answer, you have answer to every question, and you'll be able to manage the parties correctly. So yeah, get qualified. Then it's, if you want to further your studies as well, to do your master's in dispute resolution or international law or related subject, why not? It's something that you should also, because the more you understand the space or the subject of law, the better for you as a mediator, right? Then one thing I will also advise is that if you are starting out, it's possible that you are unable to get a law firm that is more, that is specialized in mediation. Mediation is your passion, right? But the market is very small, right? Maybe the firms we are seeing are the firms doing litigation, doing arbitration, doing project finance and things like that. Don't worry. Our advice are you go into them while you keep your eyes on the goal, which is mediation. You can take certain certification to qualify as a mediator. You can attend conferences, events like this. When I started interest in arbitration, I started with webinars, conferences, before now going for advanced studies and specializing in the area. So these are some of the things you can do too in order to still get yourself prepared to become a certified mediator. So take the opportunities that come before you, but keep your eye on the goal. Acquire a lot of knowledge as much as you can as certifications, and at the end of the day, you'll be better for it.
Thank you very much, Isaac. Ladies and gentlemen, you don't hear any regrets. They have all embraced their journeys. So I hope you're also trying to embrace yours. Not with we could have done, but that we are doing, and this is our situation, and we will keep our eyes on the prize, as Isaac says. Lois, law firm, mediation, criminal practice, where to start when you're building this?
You start with where you are, with what you have, with the skills that you have, and especially with what you love. Like now for mediation, I think it's back in 2021. And that time, other than DRHA, I think I visited over 20 other institutions that were there on the ground, on Google, but there was nothing on the ground. So finally, when I went to DR Hub, where Assunta is the founder, that is the first organization that opened its doors, because I was anxious. I wanted to meet other people who are in that space, because there were no people, and if there were, maybe they were also looking for other people. So slowly by slowly, we have gotten into groups, like now there's women in ADR, there's DR Hub. There are many other things that are coming up. But I think it's just that interest, that passion to pursue what you love. That is what I did. And at that time, I had begun law mediators. So I used to tell them, I printed my cards, I told them I'm a mediator, this is what I do. Anywhere where I would go, I would just introduce myself. This, I am a mediator. These are the services I can do. This is what mediation. I was excited to talk about it. I'm still excited to talk about it. So that is the drive that I get from mediation. I am passionate and I'm happy to see it growing, because now when I was beginning, I felt that there was no, people didn't know about it. So I started writing about it. I started writing about what I do, and slowly by slowly, people got to know. People are able to know what mediation is, how it can benefit them. So that is how I was able to get into the mediation field. But right now, if I were to advise you, if you are getting into the field, don't get into it because you think there's money. Isaac has said it's still a small field. Phyllis has said it could not pay. Still, it is still a small field. So we are still looking at the price. It is your zeal, it is your drive that will get people to know you. And when people get to know you, that's how you're able to let them know how you can be of help to them, the solutions that you bring on the table. And that is how you're able to get people's trust and assist them in their disputes. In the practice of the farm, uh, right now I would say we don't take matters directly to court. First, we have to negotiate, not mediate. We have to negotiate with the other party. In the event that we are not able to, then now that matter goes to court. But when you bring a matter to my desk, first thing will be to analyze whether this matter can be settled or not. In the event that the other parties are not compliant, then that is how we find ourselves in court. Just like Phyllis said, there's a place for everything. There's a place for mediation, there's a place for negotiation, there's a place for arbitration, and also there's a place for litigation. So take heart, let the zeal lead you. Don't give up even if it looks dry. Just keep showing up, webinars, keep going for the physical. That's how you're able to meet such panelists who are able to hold your hand. So thank you so much.
Thank you very much, Lois, and I attest to attending these things because you will meet, I can promise you I've met each of these panelists in very different spaces. And yet here we are together for this particular session. So showing up does count, ladies and gentlemen, please note. Phyllis, as a trainer, would you say we're looking at trade? Our continent is promising and hoping upon AFTA. And here we are training our lawyers and our ADR practitioners the same way. Do we need to shift this? Just for those in the room to understand, can I qualify as a trade mediator? What do I need to do?
Thank you very much, Assunta. I like what my co-panelists said. Depending on your area of interest, just make sure you know more. But basically, first there's the basic mediation training, which is 40 hours. That one is very important and it cuts across. But then now, should you have an interest in a particular area, then it will only be good and wise for you to get deeper in that particular area. When it comes to trade, it would be good for you to get to understand all the after protocols and how things are done. Being in trade, again, you should understand how COMESA does its things, SADC, across Africa, and generally platforms like WTO. So there is a training fine that we do for cutting across. But when you have an interest in a particular area, it is now upon you to go deeper in that particular space so that you are more equipped and better placed to handle the disputes in that area. You find like, yes, for trade, there's the commercial instruments and the treaties that it's good we understand. Then when it comes to families, there's the family law you have to understand. There's the element of succession. But yet again, whether we like it or not, there's a bit of the advantage of having a legal background to some good extent or also doing your research. Because one, there's trade as trade. But again, we have disputes across countries that are family-based. A case in mind is when, for example, unfortunately, there's a divorce and the parties are coming from different countries. How would you deal with that? It will definitely affect the trade, and it will also affect the family itself. And then you'll find that the law for adoption, the law for guardianship is different across the different sectors. It's different. It's different across the different religions. Again, those are some of those things that should you find yourself in any of these unique areas, just dig deeper to understand. If you're dealing maybe with some Islamic people, just understand how the Sharia law works. If you're dealing with an European married to a Kenyan and now they have split, get to understand how it works and also how their property will be. I remember one of the matters again I was dealing with at some point. It was an American who had married a French person and they were living in Kenya and now they were going through their divorce. So you find here there's the element of their property. How should it be? Should it be handled? And then again, you find, for example, under the civil law, there is a way where they have a common fund where both the spouses during their working years, there's some money that goes into that kitty. You see, we don't have something like that in Kenya. I mean, it's not a demand. So when things are coming up and these are business people and they are splitting, it becomes very tricky sometimes if you don't understand the different laws and the different cultures, so that you're able to help the clients or the parties negotiate and come up with an agreement that is amicable and that is a win-win to all of them. So bottom line, whatever it is, whatever area you're looking at, get deeper. And trade is also very, very wide. As we are looking at trade, there are those who just deal with coffee. There are those who just deal with tea. There are those who are doing oil. There are those who are doing mining, a different kind of mining. There are those who are into agriculture. And you find these goods are traded across Africa, some of them. So as you get into the mediation space and you're getting into trade, it is good to be aware of the differences and know that when a dispute comes up, if you're not up to speed, then you have to study just before, and also come up with agreements that are enforceable in both the countries or all the countries where that dispute is touching on. So basically speaking, the first mediation, basic training of mediation is very critical so that you understand the fundamentals of mediation. But now when you're getting into trade, get to understand more about WTO, AFTA, COMESA, SADC, get to understand AU, all of these organizations, how they work and the protocols are very, very critical. Thank you, Sunta.
Thank you very much, Phyllis. And I will be moving to the segment where we have our last Q&A, right? And our parting shots. So ladies and gentlemen, if you can still hear us, still with us, please raise a hand, say yes in the chat, and we will know you're still with us. This is the critical few last minutes. Should you have a question, again, please leave it in the chat. I know right now I've asked you to raise a hand to confirm you're with us, but now should you have a question, leave it in the chat. Over to Isaac. Having left and studied in another jurisdiction, would you say that is one of the benefits that can set an individual apart to develop new skills for mediation? And then for Lois, I'll be asking for some additional parting shots as we go around the table. Isaac, over to you.
Yeah, thank you, Asanta, again. So, yes, having a foreign education, it's very, very important as well. Be it mediation, be it in arbitration, be it in other professional endeavors that you are pursuing. Because what it does is that it broadens your mind. The kind of exposure you're going to have, it's invaluable. So I would say that yes, it will set you apart in terms of the additional knowledge it's going to give to you. Additional things we do to you is that it's going to also broaden your network. You go out there to go and study. There are other people from other countries coming together. You get to know them. You get to meet with them. And one way you can make people appreciate what you do is when you sit face to face with them in class, in meetings, at the coffee table. and you have conversations, right? So that's one thing having an international qualification education can also do for you, right? So yes, I would say it will help a lot. It's been helping. It's a career push, and if one can afford it or through scholarship, why not? It's something that I think one should explore at some point in one's career, and it will go a long way. And I know Asunta can also testify to that.
Yes, I can. You're quite a testament to leaving all that you know to starting life in another space. I would recommend you're never too old to be an intern or a trainee anywhere. When you're learning a new jurisdiction, you have no luxury of comfort of what you know. And everything you know is not credited to you at all. So you're starting from scratch. So for you who are listening, who want to build your mediation skills in the concept of trade and knowing that trade is international, should you choose to do any international course, know that you're starting from scratch. So put yourself in the situation of a trainee or an intern, because then your mind will be open to learning other than assuming that you know. Now, Lois, at the risk of asking people to come and line up at your door for mentorship, may I ask, would people also be mentored to build these skills from your perspective?
Yes, yes. People will be mentored, yeah. And some of the things that I would like us to take home, including now for the stakeholders, would be that ADR should become a core component of the legal education. Let's not do mediation after. Let the 40 hours be a core course, so that people are able to navigate it. You don't have to do the 40 hours much later. Let it become a core component. The second thing is that lawyers should receive training in cross-border commerce, including this African free continental trade area, so that we are aware of what is happening. Like right now, around 54 out of 55 African countries have ratified to be members. That gives us opportunities if you have trained as mediators. Because think Article 18, it gives mediation as one of the dispute resolution mechanisms under the African trade, the AFCFTA. So now this is something else we need to cultivate. Opportunities are coming up. So as Phyllis said, you should be equivalent. You should be what is it called? You should be up to task once they are opened up. Once it is opened up, now we know all the countries, in as much as the funny thing, Asunta, around 5 countries are the only ones that have ratified for the Singapore Convention. Out of the 55 African countries, only 5. But this other one, the AFCFTA, came back in 2020, and now we have 54. I was wondering why. Maybe we need some homegrown solution. People are looking at homegrown, but now that binds us as Africans. Now we should be able to open our borders. In fact, the only country that has not ratified is Eritrea. So if we have somebody from Eritrea in our midst, kindly let them get on board. Advise the country that the AFCFTA is good. Let us work on it together. Let us be on board together. So that is what I was saying, Asunta. Let the lawyers be trained across all these things that are coming up. The Singapore, the African Free Continental Trade Area, and many others that are coming up, so that once you're done with the education, you can seamlessly get into practice or explore new areas of practice outside the normal practice areas. The other thing that we need to do as a take home is cultivation of soft skills. This includes emotional intelligence, active listening, the skills that we are taught in mediation, the communication skills. Let us cultivate that. We also need to have collaboration across African institutions. Right now, Women in ADR, I think this is a good platform because we have had students, we have had people from different institutions. We have people from different countries who want to learn what we are doing in Kenya. We also want to learn what they are doing in their country. What is South Africa doing? What is Nigeria doing? What is all these other countries doing? Let us have collaboration across all these African institutions. Thank you so much.
Thank you so much, Lois. And we take it as your closing remark, right? You have called us to action. I will not add to it, but I will allow Phyllis to add, and Isaac, you will close it up for us as I give final instructions. Phyllis, adding to the closing remarks you had?
Okay, what I'd say, particularly from the trade perspective, because today we are looking at trade, is that the fact that AFTA has come in, I'm just avoiding saying the C letter because it becomes very long, with it projected to multiply intra-African trade, because that's what we are looking at. The next generation must be trained as mediators, negotiators. Even if we have litigators, the next generation must be trained as mediators wherever they are at, just to emphasize what my colleague has said. And the importance of things like negotiation is very, very, very critical. The law curriculum should integrate ADR from the start, not just as an elective. For me, you say I encountered it in the 4th year. And then we must also learn cross-cultural competence. Bridging common law and civil law, you realize in one law, one is guilty until proven innocent. Another one, you're innocent until proven guilty. So those are things that we all need to learn and understand, particularly once we are digging deep into intra-African trade. Then just very obviously, we must also master digital mediation. I realize we are not very strong as Africans when it comes to digital dispute resolution, because we don't know how to pick body cues, body language very fast, but we have to get better at that, because body language really matters so much when it comes to dispute resolution and this ADR aspect. And particularly because many trade disputes will be resolved online, we have to be up to speed with that. So again, just as I say, train lawyers to be consensus builders, not just litigators. Because where we are at, the dispute systems should be looking at protecting relationships and not just contracts. So that's the importance of having lawyers and the community trained as mediators and negotiators, not just litigation and having a day in court. Thank you very much. And so that disputes can be concluded at a commercial rate, not at a litigation pace. Thank you.
All right, thank you so much, Phyllis. I'm taking that as a note as well. At a commercial pace, not at litigation pace, right?
Yes.
All right, thank you very much. Isaac, we are going with one-liners. Feel free to add in yours.
Yeah, so just building on what Phyllis has said and other co-panelists, I think, yes, the next generation should be trained as consensus builders. As a litigator, as an arbitrator, a mediator, I know that a lot of time is spent doing arbitration and litigation, right? So, and when it comes to cross-border transactions, time is of essence. And we can afford, as we continue with this trade integration that we're having on the continent, we can't afford to be wasting time in dispute resolution. So, and one way we can do that is to have people that understand the mediation, negotiation, or that ADR mechanism by which disputes can be quickly resolved. And even when we have arbitration, you know that no, you can have a mediated or a negotiated award that will be entered as consent award. So if you have lawyers trained as consensus builders, they will understand this, and they will be there to facilitate instead of exhibiting their adversarial skills as if they are in litigation or arbitration. So, and a number of things have been mentioned on how to do that as mediators, having the mentality of mediator. And one thing I would just add to that is that as a mediator or as a counsel representing clients in mediation or even any dispute, always put yourself in the shoes of the other parties. The starting point, if we see, okay, how is this person viewing this? How are the stakeholders behind this party viewing this? How are the public that this party is working with, the customer, the supply chain, the suppliers, how are they viewing this, right? If you understand that, then you will be flexible in the way you push across your demand or your positions when you are negotiating or you are in a mediation session. So having consensus builders who understand the place of being in the shoes of others will go a long way in preparing our next generations as consensus builders and as mediators. And another thing we should also add is that while you are a consensus builder and you are seeing yourself in other person's shoe in order to understand how you can meet at some point, understand the pain point of that party, don't forget that the ground must be leveled. That is very critical. So that is where your knowledge of litigation, arbitration will come in. So if the grounds are not leveled, there can't be any successful mediation. Right. If one party is saying that, oh, he can tie down the other person, if one party is saying that he has some advantages over the other person, then he will not be negotiating in good faith or mediating in good faith. So that's also important. Why you see yourself as consensus builder and you see yourself in the shoes of others, always ensure that the grounds are leveled. I think those would be my parting words. Yeah.
Thank you so much. Ensure the ground is leveled. We're taking that with us. And to my panelists, it's been an hour plus. I thank you for your focus. It takes a lot of brain cells to keep on this and to remember exactly what you've been asked and to interact. So ladies and gentlemen, please give our panelists their flowers. Final flowers, if I may call it. Let us appreciate them for the wisdom they have shared. It has been critical to hear their lessons, their journeys, and how they continue to practice. My rallying call to us as the attendees, it does not end here. This is just a pre-moot webinar. So the moot is coming up. You can participate. There's an option to participate through membership to the Women in ADR. The link has been placed there. But also to connect with us. So I make a rallying call that after you get off this call, make your impact by sharing what you've learned online and tag us for those conversations. We'll be happy to chime in and add into those conversations because that is how it starts. I will also appreciate two individuals. One who is Caroline, she joined us. She mentioned that she is a sign language interpreter from Nairobi, Kenya, and we had not recognized her attendance, so we must. And then equally the contribution from Philip, where he has said he has learned a lot and he will keep learning. So please go in to LinkedIn, as Philip has mentioned in the chat. Tell us what you learned from this. Tag us and we will be there to comment and to build on what we have shared, right? And for your focus and for your attention, I thank you very much because this recording will also be shared with you. Now, when you came into the room, you didn't know these particular sets of individuals or you just seen them. So I will ask them to keep their videos on. And as you exit the room and have yourselves a good afternoon, please give them a clap or a thumbs up and you can leave the room as they stay there right on your screen to receive their flowers. Thank you for your attendance. Have yourselves a good afternoon or evening from wherever you're from.
Thank you.
Thank you. Thank you very much, Michelle, Ekaran, Frederick, brilliant.